I made it clear to the Supreme Court that my fear is that I do not want Nnamdi Kanu to die in detention.
Breaking news. The Supreme Court of Nigeria today adjourned the hearing in the suit filed by the IPOB for the release of their leader, Mazi Nnamdi Kanu, to September 14th. Recall that IPOB on the 3rd of November 2022 filed the suit at the Apex Court against the verdict of the Appeal Court, which stopped the release of its leader. The Supreme Court had on April 27, 2023 heard the case but adjourned the matter till today. We have been reliably informed that the reason for the adjournment is that the court granted the application of the AGF file to file additional processes in response to Mazi Nnamdi Kanu's latest filing, which was done on Tuesday night, May 2023. The court also said that even if it hears the appeal today, being the 11th of May 2023, it does not have space within its busy calendar to write and deliver the judgment within the 90 days deadline set by the Constitution. According to the PM, Biafran Republic government in exile, their concern is that while other court judgment has been violated with impunity, they are not waiting for another court judgment. It's either Mazi Nnamdi Kanu is freed on or before 20th of June, or they wait the worst civil disobedience from the Biafrans. Now watch these videos from today's court sitting.
I made it clear to the Supreme Court that my fear is that I do not want Nnamdi Kanu to die in detention. I gave the example of Audu Abubakar, former governor of Kogi State. He was my client, and I continue to warn the prosecution that time to hurry up and carry out this trial, because if this man died, then there will be no person to try. And when he eventually died, the first time we go to court, I asked them, can you now go and try a dead person in the grave? You cannot. So our criminal justice system says, come and stand trial. What does it connote? Come and stand trial means you should be well and heavy enough to stand a trial. It didn't say come and sit down trial, or come and lie down trial, or come and prostrate trial, or come and kneel down trial. It says come and stand trial. So you should be heavy enough to stand. That is what it connotes. So I told the Supreme Court that my worry is that I would not want Nnamdi Kanu to die in DSS Gulag because of their delay. They have been delaying this matter. This trial started since December 2015. They went from 4 counts to 7 counts to 50 counts. Amendment. They did 7 amendments. If you were sure a person had committed a crime, why were you engaging in 7 amendments? And of course, the last 15 counts, I went after their jugular. The Federal High Court struck out 8 of the 15 counts based on a preliminary objection. We took the remaining 7 counts to the Court of Appeal. The Court of Appeal, on the 10th of October 2022, struck out the remaining 7 counts and further ordered that Nnamdi Kanu was discharged and that he should never again be detained and he should never again be tried on those offenses for which he was standing trial before his brutal, excruciating, torturous, extraordinary rendition from Kenya on the 27th of June 2021, after he was literally kidnapped and captured on the 19th of June, when he went to Kenya voluntarily as a British citizen and was kept in a decrepit, non-government place for about 8 days before they flew him back to Nigeria. Based on that, the Court of Appeal held that even in arresting a person within Nigeria, you still have to go through the provisions of AJA, like Section 8, which say you must treat a suspect or a defendant with humanity. You must not subject him to degrading and inhuman treatment. Section 113 of the AJA is there. Section 94 of the AJA is there. All of them say you must comply with both local and international laws in trying a suspect. They did not subject themselves to extradition proceedings as provided for by the Extradition Act, laws of the Federation of Nigeria 2004. And there is also the doctrine of specialty, that you can only try a person even if they had engaged in lawful extradition proceedings, which they did not do. You can only try a person for the offense he was standing. You cannot try a person for the offense he was standing trial before his extradition, extrajudicial or extraordinary rendition. It has to be a new offense for which you are extraditing the person. But they didn't do all this. So the Court of Appeal saw through the federal government's facade and masquerade and tore it to shreds and discharged Nnamdi Kanu, ordered that he be not detained, and ordered that henceforth he should never be tried. But the federal government surprisingly went to the same Court of Appeal, but another panel this time, to ask for a stay of execution.
Ask the question.
Yeah, good morning. Yeah, today's proceedings border essentially on the main appeal, which we believe was ripe for hearing. When this case came up on the 27th of April, Thursday, 27th of April, the Supreme Court ordered the federal government to file their brief of argument as appellant within 6 days. They had asked for 5 days, but the Supreme Court was gracious enough to give them 6 days. They did not file that brief until Tuesday. Even when they filed it on Tuesday, I discovered that the brief was 53 pages more than the threshold of the 40 pages allowed by the Supreme Court. I am not the kind of lawyer to embarrass opponents, so I told the Supreme Court, I told Ghazali SAN from the Federal Ministry of Justice and his junior, I called them and then also wrote to them that the practice and convention at the Supreme Court is that a brief should not exceed 40 pages. So they had to file another one on Wednesday, which they served us late on Thursday. We had only the weekend to prepare our own respondents brief, which we duly filed on Tuesday in the morning and served them. So from all intents and purposes, the appeal was ripe for hearing. But today, the federal government came and said they wanted to file a reply brief. I told their counsel, you can even, these points of law you are showing me which you want to file formally, you can stand up and say them orally, verbally, and we will not oppose. In any event, you are saying we raised a preliminary objection in our brief. It was raised in our brief, not as a separate document. But I believe that their own intention was to stall the proceedings, because he said he had the instruction of the Attorney General that he must reply to it. I said, no one is saying you should not reply, but it doesn't have to be in a written form. You can reply orally. We have all done it now and again by replying orally, verbally. He will not do that. So the Supreme Court said, in order not to show them out, they will give them a short time to file the reply within 2 days. Then I begged the Supreme Court, I pleaded with the Supreme Court to give us the shortest possible date. Even this month, or early next month. But they looked at their calendar and their docket that is pitiably full. It's so unfortunate this is the busiest Supreme Court in the world, because all manners of cases come here and politicians will fight themselves dirty and they will all end up here. And even the smallest case about stealing a piece of fish or disagreeing over disagreement between a husband and a wife will end up at the Supreme Court. That is why I've crusaded again and again over the years that we should have hierarchy of courts within states, so that each state of the federation should have its own hierarchy of courts, from magistrate to customary court to high court to court of appeal to Supreme Court. This is how it happens in the United States of America, from where we borrow our presidentialism. But here, the smallest case will go from the smallest village and end up at the Supreme Court. And all the politicians will fight dirty, will quarrel, will not put their hearts together. All of them will come here. So when the Supreme Court is beginning to have like 19 cases in one day, like a magistrate court, then you know there's a problem. So they looked at their dockets and discovered that the next available date is after the vacation, which will be 14th of September. Having indicated, I pleaded with the Supreme Court to allow any of the two motions which are still existing that we filed. One is motion for bail, and the other one is motion to transfer him from his current DSS gulag. I don't call it detention, it's gulag, to Kuje Correctional Center, which the federal government indicated that they are also opposing.
Well, first of all, my name is Adjournment. I'm born on the Kansas to Mazi Nnamdi Kanu. This whole thing is straightforward. As far back as 13 July 2021, that's like barely 2 weeks after Mazi Nnamdi Kanu was illegally.
I will fight you. You know what made I post this video? PG.
Okay.
Manage it the way you can. Just
okay.
Manage.
Okay.
What? What's happening for court today?
Well, what's happening for court today? Be say, court talk and say they will do this case free sham batakba on September 14 because they know get time when they go take right the judgment they do and today. But you see, the thing where they happen, we say this judgment where they go give, even people already they will get idea the thing where that judgment will be. It cannot be any other way. Because if you look at my tweets on 13 July for 2021, after 2 weeks, they went them bring Mazi Nnamdi Kanu illegally into the country. I made it clear. I took a position, say the thing when they do I'm not extradition. The thing when they do the extraordinary rendition. And today, now that extraordinary rendition, I ain't see there for Supreme Court. So our hope we say with all this delay where they occur. On that 14 September when they come, the Supreme Court agree with that position. Why it take almost 2 years ago, say this thing extraordinary rendition. The extraordinary rendition will be extradition. And person way suffer this kind of thing. You know if you try and you know if you detain them, you no get choice than to let them go. That's what happened.
So when we come on the 14th now waiting we go they look, where we go they expect?
Well, the thing we say the court will do what is called definite hearing. That means say every lawyer for one side and the other side, they go get up, adopt all the processes where they don't file, come do small oral argument. Then the court will come now, retire inside, go think about the case before they come give judgment within 90 days.
Thank you.
Thank you, Elizabeth.
Thank you, sir.
Thank you.
Okay, this is Mazi Nnamdi Kanu. We are reporting live from US. So, guys,
additional processes adjourn the matter to 14 September. Despite the fact that this matter could have been had today, the court said that even if he hears the court today, he hears the matter today, he will not have the time to write the judgment within 90 days as required by the Constitution. So the matter was accordingly adjourned to 14 September for definite hearing. So meaning on that 14 September, this appeal will be concluded substantively and all the ancillary motions will be disposed of and judgment rendered.
Okay, on the 14th of September is the final judgment. That is what
final hearing. Yes.
Okay, all right. Thank you very much.
Thank you so much.
Thank you very much.
Thank you.
This is Mazi Nnamdi Kanu reporting live for Ultimate Viewers.
Thank you. And with me here is Mazi Nnamdi Kanu's in-law evangelist, Dozie Anyanwu, and this is Rabbi Daniel, Jewish leader.
Okay.
So we are happy to be here to show solidarity with Onyendu Mazi Nnamdi Kanu. We are happy that the matter did not proceed today as we expected.
Okay. Thank you very much. Please share as you watch.